This is a University of Otago podcast.
Welcome everyone to a wonderful occasion that we have every year in the law faculty, where the New Zealand Law Foundation, I think with much vision, has decided that we have coming to New Zealand every year a distinguished visiting fellow, so they can go and visit all the law faculties in New Zealand and share their wisdom with us. And this year we're particularly grateful to have Professor Zellick, who's come to share his wisdom with us tonight. Just to give you some background about Professor Zellick, he has a MA and PhD from Cambridge. He was also the Ford Foundation Fellow in Criminal Law and Policy at Stanford. He was a member of the Faculty of Laws at Queen Mary for nearly 20 years. He was Professor of Public Law, Emeritus Professor of Law, Head of Department and Dean, and he's also Dean of the University Faculty of Laws. From 1990 to 1998, he was Principal of the College when he became Vice-Chancellor of the College and President of the University of London, which is a massive job. Very big university to be Vice-Chancellor of, Graham. Since 2003 to 2008, he has been Chairman of the Criminal Cases Review Commission, so he's very familiar with the topic we're talking about tonight. And currently, he is the President of the Valuation Tribunal for England, a new tribunal which is set up to look at property tax appeals. Graham has been an electoral commissioner, member of the Competition Appeal Tribunal, the Data Protection Tribunal, the Criminal Injuries Compensation Appeals Panel, the Lord Chancellor's Advisory Committee on Legal Aid, a magistrate in London, and chairman of the Committee of Heads of UK Law Schools. He was editor of Public Law, which many of you will be familiar with, and the founding editor of European Human Rights Reports. He's a Master of the Bench of the Middle Temple, Honorary Fellow of Gonville and Caius College, Cambridge, Honorary Professor in Law at the School of Law at the University of Birmingham, and Emeritus Professor of Law at the University of London. He's also an associate member of 3 Verlaine Building, Gray's Inn. And just recently, Her Majesty the Queen has honoured Professor Zellick when she approved the appointment of 5 Queen's Counsel honoris causa, honorary silks, an honorary appointment recognising a major contribution to the laws of England and Wales outside of the practice of the courts. Professor Zellick was given this appointment because of the work he's done in developing prisoner law and prisoners' rights, both as an academic subject and in practice, which is a great tribute to you, Graham. We congratulate you very much for that. It's my great pleasure to invite Professor Zellick to present his lecture tonight on a topic which I'm sure we're all very interested in, and we've had many cases like this in New Zealand, sadly, the investigation of possible miscarriages of justice and the quashing of wrongful conviction. Please give Professor Zellick a very warm welcome.
Thank you very much for that very kind introduction. It's an enormous pleasure to be here. I want to thank the Law Foundation, which has made this visit to New Zealand possible, and I want to thank you for the splendid arrangements you've made for receiving us in Dunedin. I come before you without any of the usual technological props that characterize lectures these days, so I must apologize for that. But let me give you some idea of the way in which I've organized my remarks this evening, so you have an idea of where I'm going. I thought I'd start by giving you my views about why post-appeal machinery is required in the criminal justice system. And then move on, secondly, to assessing the different models for such machinery. The traditional model you have in New Zealand, and a couple of possible alternatives, and why I happen to think that one method is greatly superior to the others. Then, on the assumption that such machinery is desirable, I'd like to identify some of the essential features of any new arrangements. And then look at, fourthly, in a little more detail, at the test for referral, the test, in effect, for reopening a case in the courts. I may, if there's time, say something about the scope of such machinery, which convictions, which sentences and so on it might cover, but that's not absolutely crucial. Also something about the composition of such a body and the way it might work. I very much hope I've got time to give you a few examples of some of the cases that the Criminal Cases Review Commission in England has dealt with, just to give you a flavour of the work, and if I may say so, the successes of the body. And then finally, some concluding remarks about the benefits of moving to such a new system. So why is post-appeal machinery necessary? When I say that, I mean something over and above what is provided by the normal judicial system. Finality in civil litigation is everything. It's an ingredient itself of the quest for justice. The parties need to be satisfied that they've had their day in court, or days, and that the decision of the court, once it's reached, whether on appeal or otherwise, is the end of the journey, and they and other parties who are following the litigation can proceed, whether they're private individuals or corporate bodies, can proceed safely in the knowledge that the law has been articulated. Certainty is everything, finality is vital. And it's exceedingly rare for a civil case to be reopened, virtually unknown in the common law system, for a civil case to be reopened once the normal appeal mechanisms have been exhausted. Not so in the criminal law. Finality is no ingredient of criminal process. Quite the contrary. The door to correcting miscarriages of justice has always been open and must always be open. But when I say has always been open, often in a somewhat illusory sense, open more theoretically than in practice. But it's always been possible in nearly all systems for somebody, somewhere, to move the system to put right a miscarriage of justice. Now, if you're going to have special machinery beyond the normal appellate procedures, it does really presuppose a pretty good and sound criminal justice system to start with. If you've got, as some countries sadly do have, criminal justice systems which leave everything to be desired, lack of fairness, lack of equality of arms, lack of proper legal representation, unfair procedures, and things go wrong, you can't put it right by a review mechanism of any kind. So in recommending, as I do, systematic arrangements for the review and correction of miscarriages of justice, I presuppose that the criminal justice system in question is a good one. And that is my view of the English system, as it is in other Commonwealth countries which have been debating this matter for years, Australia, for example, Canada, for example, and New Zealand. You can't graft it on to a poor criminal justice system and think that you're going to produce justice. It also presupposes a mature and confident judiciary that can cope with people like me telling them to look again at a case that they've already looked at. And believe me, that isn't always the case. I don't think it was the case in England a few years ago. And I doubt whether, if the Criminal Cases Review Commission had been set up in England several decades ago, I don't think it would have worked. It's terribly easy for the judiciary to frustrate and obstruct the work of such a body if it were so minded. So again, it presupposes a mature and confident judiciary. It also presupposes the possibility of creating an entirely non-political body. I've quite often talked about the work of the Criminal Cases Review Commission, the English Commission, in the United States. And when I've made that point, I see the faces of the audience, because the very idea that you might be able in America to design a non-political statutory public commission is just unthinkable. It isn't possible to do. The culture doesn't accommodate it. Now, I don't know what the position in New Zealand is. I haven't asked anybody and I haven't been told, but I assume it is possible. It is certainly possible in England. But if you can't remove the arrangements from politics, then there's no point in trying. So again, so there are three requirements, really, before it's even worth thinking about creating the kind of review mechanism that I have in mind. The other point to note is that the cost is tiny. It's minute compared to the resources that any modern society invests in its criminal justice system. When you think about the police, when you think about prisons and probation and the prosecution service and criminal legal aid, and add all that up, it is a very large sum of money indeed. The Criminal Cases Review Commission, which covers England, Wales, and Northern Ireland, a population of, 50, 60 million, costs about £8 million a year, and going down very rapidly, sadly. And the Scottish Criminal Cases Review Commission, in which I know there's much interest in New Zealand because the two jurisdictions are very similar in size in every respect, a little more than £1 million. So we're not talking about huge sums of money. Mind you, considering how miserable the British government made my life when I was chairman of the commission over this £8 million, you would think that it constituted a major proportion of Her Majesty's government's budget, but it was tiny. It was tiny. Now, let me just get out of the way. I could give a whole lecture on what I mean by a miscarriage of justice, but I'm not giving that lecture. I've got it with me, but I'm not giving that lecture because it's a slightly different topic. And I'm going to treat it as basically axiomatic. All I mean by a miscarriage of justice is a criminal conviction that, to use the English terminology, isn't safe. That is to say, that's a statutory term, believe it or not, in the English Criminal Appeal Act. A conviction that isn't safe will be quashed. And that's all I mean. The appeal court will quash the conviction. Now, that's a bit circular, and as I say, we could have a long discussion. But I'm not talking about people being factually innocent. Now, they may be. They may well be. And in a few cases, but not many, one actually knows they are factually innocent because the evidence makes it absolutely clear they didn't do it. But very often, you don't know that. One may have one's suspicions, but that isn't what it's about. That isn't what the criminal justice system is about, and you can't change the rules simply because they've been convicted. So the same tests should be applied whether you're dealing with an appeal first time round, whether you're a review body, or whether you're in the Court of Appeal second time round. Is the conviction safe? There is no reason why the test should change, why the standard should change. If it were to change, it would be an injustice. If the conviction is unsafe, it should be quashed. If necessary, if appropriate, there can be a retrial. That is a secondary, a derivative, a distinct issue. Okay, so I come to my second point, which is, what are the different models? What types of machinery? Well, the traditional one is the one you have in New Zealand, where there is no special, independent, separate statutory machinery, but the power rests with the executive, with a minister of the Crown. That is the traditional position in most common law countries, certainly in the Commonwealth. But there is something slightly unusual, to my eyes and my way of thinking, about the position here in New Zealand. Now, where it's all wrapped up with the exercise of the prerogative of mercy. And if you look at Section 406 of your Crimes Act of 1961, it's headed Prerogative of Mercy, and it brings in the Governor-General in Council, and therefore it involves the Prime Minister and the Cabinet and the Minister of Justice. And I was very puzzled by this, because we're really talking about a straightforward, simple, and relatively modern power to refer cases back to the appeal court. That's an ordinary, straightforward statutory power. It has nothing whatever to do with the prerogative of mercy. In Canada, it's nothing to do with the prerogative of mercy, where the Minister of Justice has that power. And in Britain, it never has anything to do with the prerogative of mercy. Prerogative of mercy is historically and legally limited to the grant of pardons and the remission of sentence. Referring a case back to a court is the exercise of a pure statutory power, and therefore shouldn't involve prime ministers and cabinets and governors general or the Crown. So I don't know how it is that Section 406 emerged in the form in which it has, but I think it's constitutionally problematic. And I think it's complicated a straightforward issue. And I tell you why, but it's not just a bit of arid constitutionalism, because my argument is this. Ministers ought never, or only in the most extraordinary and rare of circumstances, have any role in relation to individual cases in the justice system. It is a violation of the separation of powers, it is offensive to constitutional principle, and it is wrong. And it isn't justified by historical practice or precedent. Now, you see, that last point is important, because if it were really tied up historically with the exercise of the royal prerogative of mercy, that might defeat my constitutional argument. But it's not, because the power to refer a conviction to a criminal court is a relatively recent one. Now, I don't know when the Minister of Justice first acquired that power by statute in Canada. It certainly isn't a power that exists at common law, and it certainly isn't a power that exists under the royal prerogative, so it can only have been created by statute, and I should have thought it could only have been created relatively recently. I mean, in England, we didn't have a court of criminal appeal until the early 20th century. I don't know whether New Zealand was ahead of us or behind us, but it's a relatively modern concept. And therefore, I think one ought to be looking through contemporary constitutional eyes at this practice and raise serious questions about the propriety and the correctness and the appropriateness of a minister of the Crown having a role in relation to individuals in the criminal justice system. So I do say that there is something that isn't right about these powers resting with a minister, even if it worked perfectly, which for all I know it may do. But I would be surprised. Now, I should say, I know, because I met the officials only yesterday who do this work, and it's quite clear to me they do it with great integrity, with great dedication, and to the fullest extent that they can. But there's two other reasons why it shouldn't be where it is. One is it does not inspire public confidence. And that accounts, in all the countries where it exists, as was the case in Britain before 1997, it accounts for the relatively small number of cases. The moment you set up a properly independent body that commands confidence, the number of cases grows, not unmanageably, but significantly. So it doesn't really do much to promote public confidence in the criminal justice system and its potential to correct, its capacity to correct errors. And that's unfortunate. The third reason why it shouldn't be where it is this, and I'll develop it more in a moment, and it is this, that an effective review body, above everything else, needs quite awesome powers, and some of the powers we have will surprise you, I think, but needs quite awesome powers to do its job. You could not properly, in my submission, give those powers to a minister of the Crown. Not, I hope, in a civilized society governed by the rule of law. I think it would raise serious problems if ministers were going around doing what the Criminal Cases Review Commission does. But I'll come to that. That'll just keep you on tenterhooks for the moment. What does he mean by that? So a number of reasons why I think there's a jolly good case for introducing different machinery and removing it from the political sphere. I know that that isn't going to happen overnight. I only hope that it's not, as it was in England, a whole series of absolutely appalling miscarriages of justice in the 80s and 90s that shook public confidence in the criminal justice system to its foundations to bring it about. Isn't it sad how often that social and constitutional and legal change only comes about in the wake of some disaster, catastrophe, error, or injustice? But there we are. That's the democratic system for you. Now, what are the alternatives if you don't have the government doing it? Well, the obvious one you might think is the courts. We have appeal courts. Why don't the courts do it? Well, that's very simple. Because courts are reactive bodies in the common law and Anglo-American system. Quite rightly, you've got to be very careful about recasting the courts in a completely different role for one purpose. Courts sit back, people come to courts with arguments and submissions and evidence in an adversarial setting, and the court rules and adjudicates. It's absolutely fine. I'm a great fan of that system. That isn't, though, the way a review commission dealing with miscarriages of justice can go about its work. It isn't adversarial, it isn't judicial. It has to go out there, and I come back to the awesome powers I talked about a moment ago. You've got to go out there and do the business. Get your hands dirty, roll up your sleeves. It's a messy business. And courts can't do that. So it's simply axiomatic. It's not a difficult argument to make. It is not a role that a court in our sort of system can perform. It simply isn't. It's never been, the problem with correcting miscarriages of justice isn't about getting cases back into court. It's about equipping the whatever you want to call him at this stage, he's neither defendant nor appellant, but the convicted person. It's about equipping that person who possibly should not have been convicted in the first place. It's equipping him with the wherewithal that means going back to court will produce or might produce the result he or she is looking for. So courts aren't a possibility. The courts come into it because I believe in a system which harmonizes with the judicial system. There are alternatives. I'll talk about that later. I believe in harm, otherwise you end up with conflicts which are not happy. But the actual review, which is the important element, is not something you can leave with the courts. So that leaves the third model, and that is a freestanding, statutory, independent body of some kind, like the Criminal Cases Review Commission in England, Wales, and Northern Ireland, and the one in Scotland. The only other one in the world, amazingly, is in Norway. And it remains a matter of profound surprise to me that after a dozen years of experience of the English Commission and over 10 years in Scotland, that other countries haven't adopted this machinery. In the absence of experience, you might say, well, it's going to be overwhelmed by cases which are frivolous and mischievous and no way it would work and so on. But, over a decade's experience in two different countries with different criminal justice systems, both have worked absolutely beautifully. And I don't think anyone would seriously question that judgment. And yet, around the world, Commonwealth countries, common law countries, no interest in taking it up. Very strange, very strange. I believe at some stage it will change, and that such review commissions will be regarded universally, certainly in the common law world, as absolutely fundamental features of a decent and civilized criminal justice system. But there we are, looking into the future. As old as I am, I still have some optimism. What are the essential features of a body? If you're going to set something up, if you're going to make a change, what are the essential features? First and foremost, independence. Independence from everybody, the applicants, their lawyers, so the legal profession, the judiciary, the government, prosecutors, everybody. It's a lonely existence. That's why coming to give lectures, was always welcome. It's a lonely existence. You tread a lonely path, and your potential critics are many, and the pitfalls are many. But independence, absolutely essential. It has to be, as I said earlier, non-political. If a country doesn't have a mechanism for ensuring that people can be appointed to public commissions in a way that is entirely non-political, and we've only got to this point in Britain in relatively recent years, then there's no point even thinking about this. It's got to be entirely free from influence from all quarters, and the people appointed have to be robust enough to resist the sort of pressures that inevitably are brought to bear, whether from ministers or members of parliament or lawyers or the press or lobbying and campaigning groups. You've got to ignore it all. It's got to be, in other words, like the judicial system, like the courts, completely free of all of those extraneous influences. The Royal Commission on Criminal Justice, which recommended in the early 90s the setting up of a Criminal Cases Review Commission in England, went so far as to say that the body should be free from the jurisdiction of the parliamentary ombudsman, which is unusual, and we are. Forgive me for saying we all the time. I shouldn't be saying that because I haven't been doing this job for a couple of years, but I can't get out of the habit, so forgive me. They said there should be no formal appeal against any decisions of the Commission. And they also said, very surprisingly, it shouldn't even, though it's a public statutory body, shouldn't even be amenable to the judicial review jurisdiction of the High Court. Now, the government didn't accept that last suggestion, and I think it would have been extremely difficult to do so. I don't think there is any longer any public body that's totally immune from the reach of judicial review. So the Commission is. The judges have rightly recognised that Parliament has given the Commission an exclusive authority and respects that, but that doesn't stop a very large number of disappointed applicants from going to the High Court and applying for judicial review. It's not altogether surprising because they've got nowhere else to go after us, and so the Commission spends a lot of its time and energy just seeing off these cases. I think the Commission's only lost one judicial review case in its 12-year history, but nevertheless takes a lot of legal time and effort. But I don't question that. I think that simply comes with the territory. Status is important. The body needs to be able to command the respect of the different constituencies. Obviously, ultimately, it will do that by virtue of the quality of the work it does, but it needs to have appropriate status, and the Royal Commission, therefore, was of the view that the chairman and the commissioners ought to be appointed in exactly the same way that Lords Justices and Lords of Appeal were appointed, that is to say, by the Prime Minister, by the Queen on the recommendation of the Prime Minister. That is the procedure, and the chairman's salary was set at a level commensurate with that of the High Court. It also needs to have adequate resources to do the job. That goes without saying. That applies to anybody. Courts have the same sort of difficult dialogue with government about resourcing, and in current circumstances that dialogue grows ever more difficult. Without adequate resources, you can't do the job. But I'll say no more about that. It's self-evident. But I do want to say something about powers, which is the next thing, because there's no point in creating such a body unless it has powers, and I've already described them as awesome. You may or may not think that's right, but I think they're pretty extensive and pretty significant. The main power that the Criminal Cases Review Commission has is under Section 17 of its governing statute, the Criminal Appeal Act of 1995, and it's this. It can obtain anything that it needs from any public body or authority. Anything. There's no limit to that. The Commission has been into the offices of the two security services, MI5 and MI6. We've been into the private offices of ministers of the Crown, of secretaries of state. We've obtained a census return, which is supposed to be inviolable for a century. We've obtained confidential medical records. This is where I should see your hair standing on end. You name it, we've done it. Telecommunications records, whatever is necessary. Now, unfortunately, unlike the Scottish Commission, we have no corresponding power at all in relation to private persons or bodies. That hasn't seriously inhibited our work, but we have been trying to get the law changed. But in Scotland, they've got a power to go to a judge and get a warrant in those circumstances. But the Section 17 power is literally exercised in every single case to obtain all the police information, anything from the prosecutors, and so on. It's terribly significant. And it's ironic because, and this is worth thinking about, but I've never actually found the answer to this, if there is an answer. The Commission can do things and get information which the defence couldn't have done, and therefore didn't do, at the time of the original trial. Not surprisingly, therefore, in those cases where that material is relevant, the court got it wrong. For example, I mentioned medical records. In one terribly serious case, where a young woman complained that her father and music teacher had both separately abused her sexually many, many years before when she was a young girl, we obtained the notes of her psychiatrist. And they revealed that the story that she confided to her psychiatrist was very different from the story she confided to the police and the court. And that, plus one other bit of evidence we got from an expert, that was enough to have these two convictions quashed. Her father had been sent to prison for 12 years, a music teacher for 10, and sadly the music teacher died in prison. Very sad, very important, very serious case, but it just shows you what... But there's no way that the defence team would have been able to access those psychiatric notes for the trial. And there's another thing we do quite commonly. It's become, this may not apply here, it's become very common in criminal trials, almost happens in, it's routine business, for the Crown to claim public interest immunity. Now, we have a system, again, it was, I think, one of the changes that followed the miscarriages of justice in the 1990s, followed the recommendations of the Royal Commission. We have a very exacting disclosure regime in which the Crown must make available to the defence any material in its possession that may either may either weaken the case brought by the Crown or strengthen the case for the defence. And it's a very serious matter if they fail to disclose something which they should disclose. It's frequently grounds for quashing. So it's a system that's operated very scrupulously. However, there is material which the Crown doesn't feel it can hand over to the defence because of its sensitive nature. Usually it's material they've got from, what do you call it, people who are giving them information, Yes, informants, that's the word, thank you. From informants whose lives may be at risk if their identity is revealed, and it's intercept. It's intercept material and tape recordings and all that. Anyway, there's a lot of stuff that they simply, even if they're not going to use it, they don't want to reveal it to the defense. That's understandable. So, they claim public interest immunity, they go to the trial judge in private, and they make an application to get his agreement, A, that it's covered by public interest immunity, well, that's pretty straightforward, but B, that it isn't material that they need to hand over. Because if it is material that really is significant to the defense, then the judge will say, I'm sorry, this is really so important to the defense that you actually do have to hand it over. At that point, if the judge makes that ruling, of course, they have to throw in the towel because they can't proceed. That's their call. But usually the judge agrees, this isn't helpful to the defense, it's not covered by the disclosure requirements, therefore you don't have to give it to them. Now, of course, the defense doesn't know even that this application has been made. They don't know this material exists. So there is no way they can challenge the decision of the judge. Even by the time the appeal has ended, they don't know any of this took place, they don't know any of this material exists. We, however, do. We have the transcript of the application made in camera to the trial judge, and we have access to all that material, however sensitive it is. And if we think that the trial judge got it wrong and that it should have been handed to the defense, then of course you're well on the way to identifying an unsafe conviction. How do you deal with it without compromising the safety of the informant or police sources or whatever it is? We do that by sending it to the Court of Appeal in a confidential annex. And there are convictions that have been turned down, convictions that have been quashed on grounds that the appellant, as he then is, and his lawyers don't really understand. Indeed, there was one case which was so sensitive that it went to the Court of Appeal, and to this day, the person whose conviction was quashed hasn't the faintest idea why. And that appeal doesn't register anywhere on any website, in any law report. But justice was done. So you've got to have some pretty awesome powers. I think we should have the power, albeit regulated by judicial filter of some kind, in respect of private persons or bodies. There was also a serious oversight in connection with our lack of international powers. There are various international agreements governing getting information in criminal justice matters from other police forces and other prosecuting agencies and so on. And we were left off all the relevant lists and out of all the relevant treaties. And so when we've had to travel abroad to try to get assistance in overseas countries, particularly in some big conspiracy cases and drug trafficking cases and so on, we've had immense difficulties because they don't know who we are, what we are, and we don't feature in any of these things. And these treaties and statutes commonly talk about the enforcement of or the investigation of crime. Well, that's not what we do. It's not the investigation of crime. So we fall outside all of this, and that too needs to be changed. The other thing that we can do, though the Commission does it very rarely, by the time I left in 2008, we'd only done it about 30 times in 10,000 cases, and that is to direct the police to carry out inquiries on our behalf. We only used to do that either when the scale of the investigation was such that it was beyond our capacity, and that was quite rare, or interviews needed to take place under caution, and that we've got no power to do that. But if possible, we did it ourselves. Now, an important point about new machinery is the extent to which it harmonizes with the judicial system. I suppose you could have a review commission that carried out the investigation and then decided that a conviction was unsafe, or there'd been a miscarriage of justice, wrongful conviction, whatever you want to call it, and quashed it themselves. That's one model. I don't know anywhere where that happens, but that's one model. Not, I think, a good one. A body carrying out the sort of role that I've been describing to you ought not also to have the final decision to overturn a conviction. You ought to keep them separate, I think. I think it's healthy. Also, if the reviewing body did it, you're really not respecting the independence of the judiciary and the role of the judiciary. And I think that would make for a very uneasy relationship. On the whole, courts ought to be allowed to put things right rather than executive bodies. So I would say that it would be constitutionally improper. Third possibility would be to, and some people have recommended this, well, since the judges got it wrong first time round, you don't want to send it back to those people. You want to set up a special tribunal of even wiser, fairer, kinder, more decent people who are going to, even if you could, I don't know who they would be, you and me, but even if you found them, again, not a happy situation because, again, it wouldn't be the courts proper, it would be some hybrid, some tribunal or whatever. And it wouldn't be feeding into the criminal justice system properly. Some of the cases we send back have implications for case law, and you need to get the court to make proper rulings. We've sent some cases we've sent back to the Court of Appeal, and the Court of Appeal said, no, we're upholding this conviction. And then the appellant's gone to the House of Lords, and the House of Lords said, no, Court of Appeal was wrong, CCRC was right, conviction quashed. Very interesting. Happened in a number of cases. So I think it's desirable. I come back to the point I made earlier. If you've got judges who are totally hostile to arrangements of this kind and want to obstruct it, of course, it won't work. It's not difficult, wouldn't be difficult for them to do so. So it does presuppose judges who believe in justice. I hope that's not an appalling proposition, but it does. It does. I tell you, another thing that makes for an interesting relationship between the Commission and the Court of Appeal, I don't think this is true in Scotland. The Court of Appeal, under the statute, can ask us to carry out investigations in cases that have got nothing to do with us. So we can refer a case to the Court of Appeal, and they can say, well, could you do a bit more work on this aspect? And we will. That's one thing. There's nothing very surprising about that. But they can also ask us, and do ask us, to do work on cases that have nothing to do with us, first-time appeals or applications for leave to appeal. And the fact that they ask us to do this quite often, I think, is an expression of their confidence in our investigative ability and the quality of our work. And year after year, they express their appreciation for the contribution that we make to the resolution of ordinary appeals. So it's an interesting two-way process, and it, I think, expresses the mutual respect. We've done that work, in particular, in a number of cases concerning juries. Now, that's a very sensitive area. I don't know whether you have, as we do, a statutory provision which makes, in effect, barging into the jury room, even retrospectively, unlawful. You can't, under any circumstances, ask members of a jury what happened in their private deliberations. But you can ask them about other things that may have gone wrong with the jury, and we've done that, and we frequently get asked, and we go off and we trace them all and ask them if anything untoward happened, and is it true that this member of the jury said he had done this and that, and so on, and report back accordingly to the Court of Appeal. So we've got developed quite an expertise now in carrying out these sensitive jury inquiries. Once we've referred a case to the Court of Appeal, the Commission is not a party to the appeal, drops out the appellant. The appellant then does his own thing. He's assigned counsel in the usual way. And the Commission doesn't make any recommendation. It refers the case, and I'm coming now on to the test for referral, which I'll mention briefly. As I say, it doesn't make any recommendation, doesn't play any part in the appeal. The test in the case of the English Commission is whether there is a real possibility that the conviction will be overturned. Nothing more, nothing less than that. In addition, there is a residual discretion so that even if that test is met, the Commission does have the power to refuse to refer. It's exercised very sparingly. Actually, a little too sparingly. It means that we've sent some trivial cases back to the... I should have said, actually, when we send it back to the appeal court, they must hear the appeal on the grounds the Commission specifies. They must hear the appeal. They can give leave to the appellant to add further grounds if they wish. That's a matter for them. But they must hear the appeal. There's no latitude or discretion on their part. There was one case we sent back where we were criticised roundly by the court for not exercising our discretion. It was the case of Ruth Ellis, the last woman to be hanged in Britain for murder. In 1953, I think it was, she shot her lover. And there'd been a campaign from the day she was executed arguing that she had been unjustly treated. It was astonishing that she was actually hanged and that she wasn't reprieved, but that was another matter. Our concern was whether she was rightly convicted of murder. I think the whole trial was over in a day. Her counsel, who subsequently became a High Court judge, didn't even make a closing submission, and there was no appeal. It was a pretty summary process. The view that we took was that there was a very real possibility that the conviction was unsafe because she should have been convicted of manslaughter rather than murder. Applying the law of, whatever it was, 2000 and something, which is what we had to do. That's another interesting point. Applying the contemporary common law of provocation, she should have been convicted of manslaughter rather than murder. So even if she was rightly convicted of murder back in 1953, that wasn't the test for us. The test, according to the House of Lords, was what was the common law at the time of the review. That was the test to apply, and our view was that there was a real possibility that she should have been convicted of manslaughter. The particular members of the Court of Appeal took a different view. I think a different constitution of the court would have thought it was manslaughter, but that's the luck of the draw. It's a little bit of a lottery, criminal jurisprudence, if I can call it that. But more than that, the presiding judge, who was very experienced and much respected, was really quite cross that he'd had to spend a week hearing this case. I did point out to him that it was his fault that he allowed defence, the appellant's counsel, Michael Mansfield, to go on for a week. That wasn't our fault. But he thought we were wasting the court's time. And it was the only occasion when I very publicly and very forcefully responded to a judgment of the court, and I said we were absolutely convinced that we were right to refer the case, and notwithstanding the strictures of Lord Justice Kay, we would do the same again in these circumstances. Another case, another example of where we exercised discretion was the case of Timothy Evans, which may mean something to some of the older members of the audience. Another person who was executed and aroused much concern at the time and immediately afterwards. And Evans was granted, some years later, a free pardon, and his family compensated. And in the House of Commons, the Home Secretary of the day who granted the pardon made it quite clear that he was wrongly convicted, but that was all that could be done. Now, technically, as you may know, a free pardon under the royal prerogative doesn't actually extinguish or erase the criminal conviction. It merely removes all the pains and penalties. A bit difficult to do that when you're dead. Indeed, the Home Secretary of the day was advised by his officials and his legal civil servants and the Attorney General that you couldn't, for that reason, grant a posthumous pardon, a free pardon to someone who was dead. But he was unimpressed by these legal niceties and did it nonetheless. We know that because we got access to his files. But we took the view that in the light of all that, the free pardon, the compensation, the unequivocal statements made to the House of Commons, there were no, and the fact this man was dead for many years, absolutely no point in sending this back to the Court of Appeal for what would be a purely technical process of quashing the conviction. Anyway, there was a solicitor somewhere who persuaded a couple of very elderly ladies, the sisters of Timothy Evans, that until the conviction was quashed, they shouldn't rest, and so they took us to judicial review. They lost, and our discretion was upheld, and it cost them a lot of money, which was sad. So I've mentioned the test for referral. I could say a lot more about that, but I won't. But you'll notice, as I said at the beginning, it's not about factual innocence. You ask the same question you ask at the first appeal: is the conviction safe? I want to. We didn't actually talk about how long you want me to speak for, and I'm probably reaching the point of no return. Composition and modus operandi, I won't say much about that. Both the Scottish and the English admissions have this in common: they are a mixture of lawyers and non-lawyers. And the Royal Commission that recommended the setting up of the English Commission was firmly of the view that this process ought not to be the sole preserve of lawyers. After all, it's the lawyers who've been involved up to that point. So, and I think that's right. The other interesting thing is, I was the second chairman of the commission. I came along around about year 7. My predecessor set the whole thing up from scratch, and a number of things he did I wouldn't have done. But one thing he did, and I probably wouldn't have done, but I think the results vindicated his judgment. He deliberately went out of his way to make sure that the staff who actually do the basic legwork, the case-working staff, weren't just lawyers. Now, in Scotland, they're all lawyers. They're called legal officers, and they're all lawyers. There aren't many of them because it's a very small body. We had 40 or 50 caseworkers. But a real mixture of people. Half of them were lawyers, but half of them weren't. And I was very surprised by that when I went there, and I thought, how can these non-lawyers really deal with this kind of work? But the fact is, sometimes experience displaces theory a bit. And the fact is, some of the non-lawyers were much better and produced results much more effectively than the lawyers. So I have to bow in the face of empiricism and say that the mixed nature of the group seemed to work. I want to just, before I finish, give you some examples of our cases. These aren't necessarily typical for this reason. Commission has 1,000 applications a year. All you have to do to get a case reviewed is to fill out a simple form, and all you need to qualify is to have been convicted in any court in England, Wales, or Northern Ireland at any time. There's no date, And indeed, you will have gathered from my reference to one or two of the cases, even being dead isn't a major handicap. I did occasionally meet some skeptical judicial colleagues, particularly when dining at the Middle Temple, who would say, when are you sending us Anne Boleyn or Guy Fawkes? and I would say, don't hold your breath. But there's a man, I can't remember whether he's in Texas or California, there's a man who keeps on writing, asking us to reopen the case of Dr. Crippen, who was hanged a while back. And there's been a group trying to get us to reopen all the cases of the suffragettes who were convicted mostly of criminal damage and criminal assault. But anyway, we haven't done that. Let me just mention a few of the cases to give you a bit of a flavour. Some of them are would be extremely well known in Britain, and some of them not at all well known. There was a major issue not very long ago about mothers who had been convicted of murder of their own babies. Sudden infant death syndrome, cot death, whatever you call it. In particular, I mean, if you were the mother of a single baby that had died, and in the nature of this syndrome, there's no explanation for the death. If just one of your babies had died, you probably wouldn't be prosecuted for anything, unless there was a lot of evidence suggesting ill treatment and so on that might give rise to certain inferences. If, however, two of your babies had died of SIDS, let alone three, chances are you're going to face an indictment for murder. And a number of women did, including Sally Clark, a respectable solicitor, convicted of murder and sent to prison for life. So not only had this poor lady suffered the bereavement of two of her small children, on top of it she was accused of being a murderer and convicted and sent to prison for life. And all of these people, many of them were convicted, largely on the strength of evidence of a so-called expert witness, a certain Professor Sir Roy Meadow, one of the leading paediatricians in the country. He first of all produced some amazingly incorrect statistics about the chances of having more than one cot death in the family. The fact is, the reality is that if you've had one, you're more likely to have two, and if you've had two, you're more likely to have three. There's a predisposition towards it. And but his evidence to the court was quite the contrary, and he came up with figures that were bizarrely wrong. And he also had some very funny theories, and they were just theories, and I think they've now been entirely discredited, about something he called Munchausen's something by proxy. And where if you had a child who was injured, he kind of, by a perverse process of reasoning, held the mothers responsible for it. It was horrible, really. And anyway, in the case of Sally Clark, the Court of Appeal first time round accepted that the statistical evidence he gave was way off, but said, oh, it didn't really matter, that wouldn't really have influenced the jury. Well, of course it would have influenced the jury. That was a terrible, terrible failure on the part of the Court of Appeal. It doesn't happen quite so conspicuously, but it was. But also, in the course of our inquiry, we discovered some important post-mortem evidence on one of the babies that had been completely ignored, showing that actually one of them at least had a respiratory infection which could certainly have accounted for the death. And that was never put before the jury. So Mrs. Clark had her conviction overturned. There was a major issue because there were lots of other cases. In the event, we only sent back 2 or 3 others, and not very many mothers did come forward. Eventually, Sir Roy Meadow was struck off the medical register, but he was put back on by the Court of Appeal. this time the civil division. He's been very lucky with his courts. In order to be struck off by the General Medical Council, there has to be gross professional negligence. And the Master of the Rolls at the time took the view that there was gross professional negligence, and with the greatest of respect, as we lawyers say, I think he was probably right. But the other two judges said, no, there's been professional negligence, but it wasn't gross, and they put him back on the register. But he's retired from practice now anyway. There was the case of Shant Jenkins, who was convicted of murdering his stepdaughter, Billie Jo. That was all about blood splatter evidence. And we went to a whole new set of experts, and as a result, doubt was cast on what was said at the original trial. As to how, because he said he went back, found Billie Jo in the garden, battered almost to the point of death, cradled her head in his arms, and ended up with this blood splatter on his shirt. The prosecution, first time round, said no, it couldn't have got there. He could only have got there if he'd beaten her beaten her to death. Our experts said no, that's not correct. The blood splatter evidence was consistent with what he said. He was retried, and I think he might have been retried twice actually. And anyway, he was ultimately not convicted. There was the case of Barry George, who was Oddfellow, who was convicted of murdering a very famous, very successful television presenter called Jill Dando, shot her on her doorstep. And the evidence that there really was almost no real evidence against him, a lot of circumstantial evidence, and he really was a very weird chap. He hadn't helped, his previous life hadn't helped him in defending a charge of murder. But what really did for him was a microscopic speck of gunpowder residue found in his overcoat pocket, which the expert from the Forensic Science Service linked with the crime, and really there's not much doubt that without that, I doubt the evidence could even have been left to the jury, but with it he was done for, and he was convicted. We went back to the Forensic Science Service and they said, actually, our chap's got it terribly wrong. And other experts agreed, and the weight placed on that microscopic speck of gunpowder residue simply couldn't bear. It could have got there in hundreds of ways. It could have been there for 10 years. It was just, it just wasn't. It wasn't the link with the shooting that the Crown originally made it out to be. He was also retried. I thought, surprisingly, given the lack of other evidence, he was retried and again ended up not being convicted. That was one of the cases where we went into MI6 because there had been suggestions that Jill Dando was actually shot by emissaries from, I can't remember where it was now, Kosovo or somewhere, because of some television program she'd made. And actually, that could well be the case, but we didn't find anything. I mean, if so, MI6 didn't know about it. That was the point. They didn't have any material that made that link. It was a bit speculative, but I dare say it was an interesting day's work for somebody. Let me just mention. Well, I mentioned that case already. Two other cases, less notorious and in a way much more important. A man with a mental age of 8 was convicted of murdering a prostitute whom he did occasionally visit. The only evidence, this was something, he was in prison for about 15 years, so it was long before they had very developed procedures for interviewing people with recordings and videos and responsible adults and lawyers present. So he was interviewed by the police on his own, and there was no evidence against him at all, only a confession that this person with a mental age of 8 had made when first taken into the police station by 2 police officers. Nothing else at all. And the police said, question for the trial judge, who's now a justice of our Supreme Court, nice man, a question for the trial court, was this confession admissible? If the police had known that he had this serious mental disability, they would not have been entitled to proceed with the interview, and the confession would have been inadmissible and so on. Anyway, the judge was satisfied they didn't know, that's what they said. Confession was admitted. He almost immediately retracted it, but too late. Once it was admitted, he was convicted and spent, as I say, nearly 20 years partly in prison, partly in a mental institution. And my staff discovered a piece of paper, one piece of paper amongst boxes and boxes and boxes of police material on the case. One piece of paper which made it pretty clear that the police were lying. They did know. It was a computer printout obtained by one of the 2 interviewing officers, and couldn't have missed the fact that he was mentally disabled. It was written, over the document in huge letters. They couldn't possibly not have known. They lied to the trial judge. And that conviction was quashed. And finally, a conviction for rape. A man went out drinking one evening. Family man, children, good job, no convictions. Went to the pub, had a few drinks, went home. 3 or 4 o'clock in the morning, police arrive at his front door, cart him off to the police station, arrested for suspected rape, ends up being convicted on the complaint of a woman at the pub, and goes to prison for, I forget now whether it was 6 years or 8 years. Now here's somebody who knows, well, I'll start at the end. Take it from me just for the moment, he wasn't guilty, he didn't do it. He knows he didn't do it, but what can he say to the court, the trial court, the appeal court, the review commission? What can he say? He's not believed. The woman is believed. It was a particularly nasty rape. There's no doubt, there's no doubt she was raped. Actually, that's not the case. It was a particularly nasty rape involving wounding. She was horribly wounded as well. And she identified him absolutely unmistakably. No doubt about that. And he was in the pub at the time and didn't have any alibi. He wasn't with anybody. So he didn't stand a chance. We made a number of inquiries. The first thing we found was that this woman had a criminal record. The complainant had a criminal record which had not been disclosed to the defense. First serious mistake. It was a record for dishonesty, and leading counsel for the Crown, who'd been asked to advise whether it should be disclosed, said, well, since that no one was saying that she was mistaken in her identity or whatever, it wasn't relevant, therefore it didn't need to be disclosed. Well, everybody, including the Director of Public Prosecutions, admitted that that was a serious error because it would have put the defence on notice that perhaps some further inquiries ought to be made about this woman. Anyway, they're entitled to know it. They're entitled to have previous convictions of a major prosecution witness. We carried on searching, and we found that this woman had made identical complaints using different names at different addresses to different police forces on previous occasions. Twice previously, she had reported being raped and injured in exactly the same way, and had identified specific individuals, different from the man this time. Wasn't the same perpetrator or same alleged perpetrator each time. But the police in the latest case just hadn't made the connections. They hadn't gone out to make any checks on her, and hadn't made any connections. We had, in both of the previous occasions, incidentally, the police rumbled her and did not bring a prosecution. The files were marked no crime. They didn't believe her. The third lot of police did believe her. Prosecution brought, conviction, appeal dismissed. Once that evidence was put to the Court of Appeal, conviction quashed, and of course no retrial. There's a case where factual innocence is established really beyond a shadow of a doubt. Finally, I'm sorry I've gone on much too long. I'm surprised there's anybody left. Forgive me. Very, very briefly, benefits of the system. Promotes public confidence in the criminal justice system in two ways, both by reassuring the public that there are really effective opportunities to correct mistakes, and secondly, it's an affirmation that in the vast majority of cases, no fault is found. It doesn't mean that every single one of them is actually correct, but no fault is found after a jolly good inquiry. The CCRC gets 1,000 applications a year. Only 30 or 40 cases are referred to the appeal court. So 96% are found, so far as we know, to be sound. 94% in Scotland. Second thing is it does actually correct injustice and miscarriages of justice. They're just some of the cases, but 70% of the cases referred result in a conviction being quashed. It removes any possibility of a political element in the process, real or perceived. And finally, it may identify issues in the criminal justice system that need attention, correction, and reform. Thank you very much.